This is an appeal in the matter of Dabo, Secretary of State.
My Lords, my Lady, good morning. I appear for the Appellant Secretary of State in this appeal. My own friends Mr Saeed and Mr Shimmick appeal for the respondent, Mr Dabo. Just before I launch into submissions, can I just deal with housekeeping?
Yes.
Just in terms of bundles, firstly, you should have a core bundle, a supplemental bundle, an authorities bundle, and then there was an agreed note that was filed separately.
Agreed note. Yes.
If you don't have it, I've got copies.
Yes, please, Mr Skinner.
I think I do. Hold on.
Authorities, I've got the call.
This is the one-page note.
It is, well, I think it's yeah, 1 page.
18th of June. Yep.
Looks like this.
This is the call bundle. You've got a supplemental.
You left it.
Yeah. That's all right, don't worry. I'll bring my computer. Right.
You ready to give it away? Or Geraldine,
No, don't worry,
Sure.
don't worry, it's fine.
The only other preliminary point to just mention is timetabling. The appeal's listed for 1 day. For my part, I think that's a very generous time estimate.
It is.
Considerably,
And
yes.
I would hope will be done by lunch in any event. My own friend and I have, we spoke about maximum time that we might take. We agreed that I would have no more than 2.5 hours, he would have no more than 2 hours.
Yes.
My anticipation is that that's a wholly academic exercise, but just so that the court is aware that I'm certainly not going to take longer than that, I anticipate significantly shorter.
Good, thank you.
Turning then to just the way I intend to structure this appeal, no surprise, I'm going to deal with the facts first, just outline them briefly. The decision of the First-tier Tribunal, I'm then going to just spend a little bit of time on, given that that I think is the focus of this appeal. And then hopefully your Lordship's new relationship will have seen from the agreed note, ground 2 isn't pursued,
Yes.
so I'll then deal with ground 1 and ground 3, and then to the extent necessary, relief. Dealing then with the facts, the easiest way to deal with this is probably by reference to my skeleton argument.
Right, thank you.
I've set out what, in my submission of the relevant facts at paragraphs 6 and 7. And further, but the background facts are 6 and 7. It might just be helpful to note that in 7C, I refer to the judge's sentencing remarks in respect of the index offence. You find those set out in the Home Office's decision letter, and the relevant page of that is core bundle tab 14, page 130. I've obviously quoted from them, but it's obviously important to see exactly what the judge said. And then in 7E, I mentioned offending since the hearings below. Now, I accept entirely, of course, that the First-tier Tribunal can't be criticised for not being psychic or anything like that, and the matters that were before it were the matters before it. But just for completeness, it may be helpful if I just run through the offending that's occurred since then, so at the very least, so that the court doesn't have the misleading impression that that's the only offending. In June 2023, he committed 4 offences of shoplifting, subsequently convicted of using threatening, abusive, insulting words or behaviour with intent to cause fear of violence, received a 3-month sentence of imprisonment and a restraining order in respect of that. In July 2024, committed an offence of being drunk and disorderly. In November 2024, there's a shoplifting offence. February 2025, there's a failure to surrender. Do you say if I'm going too quickly? In February 2025, there's also 3 counts of using threatening behaviour to cause harassment, alarm or distress. June 2025, there's assault on an emergency worker. That's the offence I referred to in subparagraph E there, for which he received 8 weeks suspended sentence of imprisonment. As we'll come on to, that was later activated. In July 2025, the appellant, the respondent, was convicted of shoplifting. He was sentenced to 3 weeks for that imprisonment. That then activated the 8 week suspended sentence, and he got a further 6 weeks consecutive for failure to comply with a previously imposed community order. He then was convicted of threatening threatening a person with a blade and theft of the person. It's difficult from the PNC to know exactly what the details are, but it sounds like it's a mugging at knife point, effectively.
That should have been charged as robbery, not theft with a blade.
That may
Street
have been-
robbery worth 4 years normally.
Well, he was sentenced to 20 months on a guilty plea.
Yeah.
He then committed a common assault in August 2025, and then most recently as an offence of shoplifting and possession of a blade in a public place, for which he received 6 months imprisonment. And as I understand it, he remains in prison.
Sorry, when was that one? We had August 25 common assault, then the date of the other one.
Let me just double check. Apologies. If it would assist, I actually have copies of the PNC.
Oh, that would help actually.
Rather than there was a dispute between us as to whether that should go in the supplementary bundle, so I don't want to. But if it would be helpful, then.
Well, I would certainly be assisted by seeing the PNC. It means that then I have an accurate record rather than relying on my own note.
My lady, if I may, there was some discussion between the parties about the extent of the supplementary bundle, on the basis that all of the underlying facts were settled and were not subject to challenge. There was quite a limited scope to the supplementary bundle, and there was discussion about the PNC, and it was agreed that it wasn't needed because whatever was on the face of the FTT determination as far as the offending history was concerned
Was what was relevant.
Yes, and what is relevant today, albeit nearly 3 years later. I am slightly concerned, I have to say, about this kind of ex post facto unpacking of a criminal history, which doesn't go to the legality or the lawfulness of the FTT determination or anything that happened thereafter. I would just sound a note of caution, if I may, respectfully to the court about...
No, I understand that.
But it's quite good to have a general idea of the history. I think we should say it.
We understand your caution, but we'll still admit it. Sorry, I didn't mean to understand your caution. Understand your submission that we need to exercise caution because the later events.
And for my part, I don't dispute that it's not directly
Yes.
relevant.
Yes.
The grounds of appeal are made out.
It's just to give an overall picture.
Exactly. So
Presumably it's a complete record.
it's dated, I think, May, so but he's been in prison since.
By that I mean it goes back over the previous history. Yes, it does.
But he hasn't done anything since that's likely to trigger yet another order or would it actually? Because
Well,
he's
the
now
20 months.
the 20 months.
would have triggered another automatic consultation process.
So help me, what would be the impact? Let's suppose your appeal were unsuccessful. Does that mean the Secretary of State can exercise a fresh discretion to serve a deportation notice on him?
I think that's right. Yes.
And then if he were to appeal that, the tribunal would now be armed with all this offending.
It would. I think the difficulty for the Secretary of State on a fresh appeal is going to be the effect of Deportation in relation to
Credibility.
well, but both credibility, but also in relation to the significant obstacles to returning in relation to the degree of integration in the UK. Now, obviously, the arguments that I'm making before Your Lordships and Your Ladyship in relation to the approach with which the First-tier Tribunal ought to have taken in relation to the relevance of offending to the question of integration are points that could be made in respect of the newer offending and the what I'm going to call the discontinued.
But you're not appealing the Camara part of it anyway. So, I mean, Deportation is a problem for you regardless. It's just something you're going to have to live with.
I accept that in some respects, yes.
It doesn't mean it's the end of the line because it's a starting point.
Of course. No, of course. And But just in terms of the pragmatics,
Yeah.
the Secretary of State's view is obviously that the decisions below here were wrong and that she shouldn't,
Yes.
Yes,
to
no,
the extent
yeah,
of appeal,
yeah, yeah.
shouldn't be stuck
yeah.
with the sort of findings that have been
No,
made.
I'm just trying to get an overall picture
Of course.
because, in fairness to the respondent says, well, all of this that is very interesting, but it's got nothing to do with the issues that we've got to decide. He's right about that,
Yes.
but it does actually put everything into perspective in terms of where we are. Yeah, thank you.
I don't disagree with any of that, my lady. In terms of the proceeding with the facts, we then obviously got the next sort of relevant stage is the First-tier Tribunal. Well, there's the decision to refuse the protection and human rights claim, and that decision is at the back of the court bundle at tab 14. You then have the First-tier Tribunal's decision, that is at tab 13. I've set it, sort of summarise that decision at some length in my skeleton. It's quite a long decision, obviously. Only part of it is directly relevant for today's purposes. Could I just ask the court, just turn it up, and I'll just take the court to the key passages, if I may.
Yes.
So the assessment of, if one just stands back, it might be helpful to note that it was accepted before the First-tier Tribunal that the appellant couldn't fall within either of the exceptions under section 117C4. Well, it wasn't accepted in relation to family life, I think, but it was found and it wasn't appealed. It didn't fall within the family life exception. It was accepted that he didn't fall within the private life exception because he didn't have sufficient residence. And so the task under Article 8 and under the statutory scheme for the First-tier Tribunal was whether or not there were very compelling circumstances over and above the exceptions.
With the emphasis being on over and above.
Of course. And because of that wording, that brings in as relevant the factors that are dealt with as part of the exceptions. And so, as is common, if not perhaps universally the case, the tribunal went through exception 1 and exception 2.
Yes.
And then one sees, and I'll just take your lordship's in relation to it in a moment, that then feeds into the ultimate analysis under section 117C6. And I just make that point just to deal with any suggestion that because it wasn't directly an appeal in relation to the exceptions, any errors in relation to the exceptions are somehow immaterial. They're not. They fed into the ultimate decision-making process in relation to section 117C6 question.
Well, it's fairly well established that the reason the tribunal does that is because you could have somebody who doesn't make one of the exceptions but misses it by a whisker. And then on top of that, you have the balancing exercise, and that may shade the way in which you look at the very compelling circumstances.
Yes, that's right. I mean, the authorities established that a near miss is not sufficient, but
No.
if there are other compelling
On top of it.
circumstances on top of the sorts of factors that are relevant to the exception, then I entirely accept that.
Yeah.
So the First-tier Tribunal's analysis under Article 8 begins. At paragraph 135. There's then a summary of the various legal principles, and there's the rejection of the family life exception at top of page 117.
Yes.
We then get to the relevant exception for present purposes, which is the private life exception. We see at 151, 52, the appellant accepts that he's not been lawfully resident in the UK for most of his life. The court would, I think, have probably noted that the appellant's been here unlawfully for most of the time here. He was given discretionary leave for a period which was extended until 2011 by virtue of section 3C, which is 1971 now. Paragraph 153 through to 161 is the tribunal's reasoning in respect of the extent of the appellant's social and cultural integration into the United Kingdom, which is key to my ground 1. So just taking that slightly more slowly, we see the tribunal reminds himself of CI Nigeria. We then get the immigration history, the girlfriend, the breakup, their relationship recommencing in 154. acceptance that there's evidence of a degree of social and cultural integration with girlfriend in terms of private life. Over the page we see received some education in the UK, number of certificates, undertaken some employment, as was confirmed in the First-tier Tribunal in 2011. It's not clear that there's any evidence of any employment since then, but so there's the phrase some employment has to be seen in that context.
I think I saw in some other underlying document that he stopped working in 2010, but I may be wrong about that.
That may well be right. That's not inconsistent with what
No.
what the FTT said at 157. 158, we get educational courses, undertaking some employment points to a degree of social and cultural integration, and then received social services support when he came to the UK, and has received some medical support with alcohol and drugs issues. And then on the other side of the balance, if I can put it that way, is, as Ms. Elliott Kelly put it, the appellant has a checkered adult life involving periods of homelessness and repeated offending. And then the limit of the judge's reasoning in respect of how all that fits together is contained in paragraph 161, where he said, when I take all these factors into account, given that the appellant has resided continuously since 2007, including a period as a minor, I find that the appellant is socially and culturally integrated into the United Kingdom.
Yes.
I'll come on in due course to make submissions about that, but that's the limit of the reasoning in respect of social and cultural integration. The judge then moves on, understandably, to very significant obstacles in relation to reintegration in Guinea.
Yes.
And we see this at from paragraphs 162 to 174. You'll see, I don't propose to read it out, I think that'll be helpful, but you'll see there's quite considerable reliance on a report by Dr. Kenny, who had earlier, the judge had earlier said extreme caution was required in respect of her report because she effectively was acting as advocate. But nonetheless, the judge felt able to obviously put some weight on what Dr. Kenny had said about the situation in Guinea. And what, relevantly for present purposes, at 162, the judge says he's applying the principle set out in Camara, and then when one comes to see the judge's analysis at 173, again, very limited reasoning, so applying Camara and making the broad evaluative judgment, I find on the balance of probabilities that he will not be enough of an insider. What the judge then does, as I've said, is goes on to consider the very compelling circumstances over and above test, and I would just note, just to make good the point about it, the exceptions flowing into the analysis under section 107C6, at paragraph 196, he notes, 122, I've already found that he's socially and culturally integrated. At 198, I also accept that the appellant, as set out above, will face very significant difficulties accessing kinship ties in Guinea. So we see the analysis under this exception flowing into the analysis under section 117C6.
Yes.
Turning then to ground, well, let me deal with the legal framework in brief. If I may assume that the court is familiar with sections 117A to D, they're in the bundle. I don't propose to take the court to it. From the agreed note, you should hopefully have seen that paragraphs 21 to 22 of my skeleton are agreed as an accurate summary of the law in relation to deportation. As I've tried to do in those paragraphs, is effectively summarise the propositions that can be derived from NA Pakistan, which you will be aware of,
Yes.
and that is broadly taken from the Justice Elizabeth Laing summary in ACTA, although it isn't quite verbatim, and then the test in HA Iraq, which you'll also be familiar with. So that is taken as that's not in dispute. So again, I'm not going to take the trouble with those authorities. In relation to ground one, the first relevant authority is Bimbuga, which you'll find at tab 5 of the authorities bundle, and starts at page 60 if you're working electronically. Just the the background for this case was that Mr. Bouga was a Turkish persistent offender. He had lots of low-level offences under a year. He came to the UK age 9 and had a deportation order made when he was 25. He was a member of a North London gang, and the First-tier Tribunal in that case had found that his gang membership was positive evidence of his social and cultural integration.
Yes.
And you'll see in the report, the relevant extracts from the First-tier Tribunal's decision are set out. It was sort of needing to think about cultural and social integration in the real world, that sort of thing.
So,
Unsurprisingly, perhaps, the Upper Tribunal and this court didn't think that that was correct.
No.
and that is the context, importantly, for the decision and what's said in it.
It is.
That there was a specific reliance on that those circumstances as supporting integration.
That's right. The
I mean, the reason I'm saying that is that, okay, it takes to bin Buddha first. Yeah. Where do you want us to go?
so paragraph 50 is where one sees, well, it's 50 to 60. Clicking for the relevant paragraphs, it might be easier if I just ask the court to read those.
50 to 60.
50 to 60.
Okay.
Take it you place reliance on 57.
57 and 58 in particular, yes.
Yes.
I've set out in paragraph 23 of my skeleton 3 propositions that I say derive from this passage. The first is that the concept of social integration refers to the extent to which a foreign criminal has been incorporated within the lawful social structure of the UK. The second is that cultural integration refers to the acceptance and assumption of the culture of the UK, its core values, ideas, customs and social behaviour, including acceptance of the principle of the rule of law. And then thirdly, and this is really the principal proposition for today's purposes, that breaking the law may involve discontinuity in integration. So that's sort of what I call as the discontinuity question. Now, of course, in a private life case involving criminality, there are many different factual permutations. That's obvious. In a number of these cases, of which Bouga was obviously one, given that he came to the UK age 9, you've got children who are brought up in the UK who then go on to commit often serious offending. And my submission is that this and the effect of CI, which I'll come on to in a moment, the effect of that is that when one is considering social and cultural integration in the UK, you don't do what the Upper Tribunal thought you had to do in this case, which was just put it all into a melting pot and conduct a multifactorial assessment. When one is considering the effect of the offending on social and cultural integration, obviously you don't positively take into account gang membership, that's clear from Bimbuga, but more than that, you have to consider the extent to which the offending has caused some degree of discontinuity or even a reduction in the social and cultural integration in the United Kingdom.
Discontinuity suggests some sort of temporal review of it. So it continues for a period, then ceases to continue, then presumably re-continues afterwards. But is that what's meant then?
I think that's possible. That's certainly possible in the right case. So you could easily have, for example, child comes to the UK age 1, or is born here and never becomes British for whatever reason, grows up, goes through school, his family are all here, he has good friends, a girlfriend, boyfriend, whatever, commits axe murder, let's say, is in prison for 20 years, his family disown him for a period of his imprisonment, he's effectively abandoned in prison by himself. You might find on those facts, I appreciate this is all very fact sensitive, but you might find on those facts there have been discontinuity by the offending and the period of imprisonment, during which period he's effectively excluded from society, not included in society. But then after he's released, I appreciate this is a perhaps unrealistic hypothetical, because one would hope that the Secretary of State, if she's going to start deportation proceedings, starts them rather sooner than this, but after his 20-year tariff, say, he's released from prison, he gets a job, he reconnects with his family and children and the rest of it, and re-establishes private and family life. So certainly it's possible that you can build up social and cultural integration, that there can then be a reduction or discontinuity in that social and cultural integration, and it might then, in an appropriate case, be re-established. And the job of the First-tier Tribunal is obviously to assess it at the date of the hearing before the First-tier Tribunal. It may help just to make good that point, to turn to the CI decision.
Yes.
Which I think is the next tab, yes, tab 6. This is a child who arrived in the UK aged 15 months. He had suffered a terrible history of abuse at the hands of his mother, and it's really quite an awful case. The relevant passages for our purposes are paragraphs 57 to 62, and then let's deal with that first, and then come on to some later passages as well. Sorry, 56 to 70. 56 to 62. And the criticism that was made in this case was that the Upper Tribunal had effectively found discontinuity, but had erred in doing it. And Lord Justice Leggett gives an analysis of how and when that discontinuity may occur and the reason for it.
Yes.
Now, for present purposes, I think it's relevant to note that paragraph 60 and 61, Justice Leggett there identifies 2 ways in which criminality may be relevant to the social and cultural integration issue. The first is the sort of first point from Bimbuga, if I can put it like that, you can't positively rely on your criminality.
Yes.
And then at 61, his lordship goes on to say criminal offending are also in principle relevant insofar as they indicate that the person lacks legitimate social and cultural ties. And then sort of between C and D, you see periods of imprisonment represent time excluded from society during which the prisoner has little opportunity to develop social and cultural ties, and which may weaken or sever previously established ties and make it harder to re-establish them or develop new ties upon release. And so in such ways, criminal offending and consequent imprisonment may affect whether a person is socially and culturally integrated in the UK. And then 62, if I can just emphasise that it's not only depends on the nature and frequency of the offending, but also the length of time over which it takes place, the length of time spent in prison, and also on how deeply the individual was socially and culturally integrated in the UK to begin with. And so that's why the 15-month-old when they come to the UK, it will require a lot more because they will have grown up and be, other than in form, to all intents and purposes, into any British citizen. Whereas someone like the appellant who came here at 16 is in a very different position, understood the culture in their country, etc. And we see that in the passage quoted at the very bottom, that somebody who becomes it from a very early age, it's unlikely that the offending alone would mean that there's.
But I don't read this as an endorsement of the, you have to, as my lord was saying, you look at it temporally, so that integration, break in integration, re-establishment of integration. This is looking at essentially all the history for the purposes of determining whether somebody is socially and culturally
I
integrated.
agree with that. I'm not seeking to suggest that there's. I'm not trying to gloss the statute or anything like that.
Yes.
The role of the First-tier Tribunal, and there's other passages that make this clear, is to assess whether or not somebody is socially and culturally integrated on the day of the hearing before the tribunal.
And the nature of their offending, the extent of it, the frequency, that's all irrelevant.
It's all relevant to,
Yes.
to the question of social and cultural integration, but it isn't. It's in my submission not just relevant as a factor to put into the mix. It's relevant. It's relevant in the sense that if somebody has had social and cultural integration and has then offended, one has to consider whether that offending is such that there has been this severance or discontinuity, whatever adjective.
But that's going back to Vinbuga, and that's not what CI Nigeria says. It doesn't say you have to determine, looking at the history as you go along. There was a break in 2015, re-established in 2018, break in 2019, re-established in 2022. And you can see why not, because that would be a ludicrous, sorry to use a strong word,
No, sure,
exercise.
I take that point, but I think there are two slightly different questions here. The one is, the first is the task of the tribunal on the day is obviously to assess whether there's social and cultural integration on the day.
Yes.
But the second is how one goes about assessing that. And my submission is that where there is serious offending or persistent offending, one needs to consider whether or not that has had the effect that Lord Justice Leggett averts to in CI and that the court averted to in Vinbuga.
Well, which particular passage do you say that Lord Justice Leggett?
So 61, where he talks about periods of imprisonment
Yes.
excluded from society may weaken or sever previously established ties.
But in the end, the last sentence, in such ways criminal offending and consequent may affect whether.
Yes, but this isn't. I'm not saying that there's a legal principle that in all cases of offending it follows that there isn't social and cultural integration. I accept that the analysis of the First-tier Tribunal is a fact-specific one,
Yes.
and will depend on the facts of each case. But what's in my submission, that's all that Lord Justice Leggett is saying at the end of in that sentence that Your Lordship's just read to me. It may be that that criminality severs or weakens the social and cultural
Yes.
integration.
Yes.
I'm not saying that there's a principle of law that it must.
What you're saying is it's relevant to ask that question.
Yes, that is
So
part of
when as part of the overall assessment, you don't say, well, on the one hand, he's been here for 16 years, on the other hand, he's a prolific offender. You have to stand back and say, at what stage in the 16 years did he start to become a prolific offender? And what impact, if any, did that prolific offending have on his integration? Did it mean he was already integrated and it made no difference, or did it weaken the ties that were already there?
Precisely.
That's your point.
Exactly. Just to complete CI, if one the court obviously had to consider the upper tribunal errors of approach, and this court did, or Justice Legate did that from paragraph 75, relevantly over 77. Could I just ask your lordship and ladyship to
Yes.
read those paragraphs as well? Maybe the passage I rely on in particular is that's from to determine, just on the right hand side of G, through to the end of up to 4 lines up from the bottom of 104.
So is your complaint really that the FTT failed to consider this point, as opposed to they applied Binbuga and got it wrong? They just failed to consider this.
Yes, they didn't apply what I discontinuity principle, or asked the discontinuity question. They just didn't apply it. They referred to CI but not Binbuga, and there's just nothing in the reasoning that suggests that this was considered at all. This discontinuity point. Can I just deal with paragraph 77? Because
Yes.
I have to say
You can see, I'm slightly resistant to using it as the discontinuity point. The way, as my lady said, it's the impact of the offending on integration rather than has there been discontinuity. Because it almost makes discontinuity almost like a term of art that you have to include it, and I don't think that's a helpful.
Well, I was hoping it was a helpful shorthand. I wasn't trying to elevate it into.
Well, that's the trouble with shorthands, is they tend to become they are elevated way above what the word.
I entirely take that point.
Okay.
Sorry, can I just press that? The overarching question, isn't it, and this comes from 57 of Binbuga, is that integration must be in relation to lawful aspects of life within the UK. So that, isn't it you stand back and ask, is the nature of his unlawful activities, whether being in prison or other things, being a gang member or just being involved in minor offences, repeat offences which don't result in prison, is the extent of all that, on balance, sufficient to undermine sufficiently the conclusion he's integrated through other lawful means?
I don't mean to avoid the question by any means, but I think it's going to depend on the circumstances in the individual case. There will be cases where what one is asked, I mean, a gang case might be a good example of this. You know, you've got persistent unlawful activity, and that might have led to somebody being absent from school, unable to work, etc., because they're in and out of prison, even though none of the offences perhaps are particularly serious. It might have just led to a sort of inability. It may be that there was never any social and cultural integration, because basically from the moment of arrival they became involved in gangs, and so that effectively kind of disinhibited the development of social and cultural integration. Then you've got other cases where you've got somebody who clearly has had social and cultural integration. The very young minor, for example, is the obvious example, who has gone through school, let's say, until their teenage years without any significant problems. They're obviously socially and culturally integrated, and in those cases, you then are asking, in my respectful submission, or you are then asking about whether or not, effectively, to use Lord Justice Leggett's language, the social and cultural integration has been severed. So it's right that the question, the ultimate question, is always: are they socially and culturally integrated at the date of the First-tier Tribunal's hearing?
It's really what impact does the offending, if any, does the offending have on integration?
Yeah.
That's the question that has to be addressed. And you say the FTD didn't do it. They didn't ask them. He didn't ask himself. How, if at all, does this persistent low-level offending until you get to the index offence impact on his establishment of a private life, which is what Lord Leggett reminded me, is really what social integration is about. So what we have is a picture of somebody who has carried out a bit of education, 2 known jobs as far as I'm aware for about 18 months at a time, but seems to have sadly had a very itinerant lifestyle, living either in a hostel or being homeless with an alcohol and drug addiction,
Yes,
and then getting sucked into county lines.
Can I just, from the passage, just before we leave CI, can I just, I reverted to the passage in 76 about the court's analysis of the tribunal's error in that case. Obviously, each case is different. I'm not trying to borrow one from the other, but what's notable there is that the criticism that's made of the Upper Tribunal, who were the primary decision maker in that case, is the failure to consider how and if, or to consider how, the offending had broken the, in inverted commas, broken the social and cultural integration.
Yes.
And I appreciate it's not necessarily the same in every case, but in my submission, if the tribunal is required to explain why it broke, why social and cultural integration, then the obvious obverse applies.
What I see in CI, was that a reasons challenge? Because as I read 75 and 76, it's really saying that the Upper Tribunal judge's decision insufficiently, inadequately explains his conclusion. Was it a reasons?
It certainly was a reasons challenge, but I think it was more than a reasons challenge.
Right.
And I think that.
Do we see that somewhere in
the?
the?
A little bit clearer from 78 through to 80.
Right.
When we see that the tribunal also sort of misinterpreted the phrase antisocial, considering whether antisocial behaviour might be the obverse of social integration.
You see, if you look at 80, the judge's many references to integration being broken by antisocial behaviour gives the impression that he saw the relevant question as being whether, through the nature and seriousness of offending, had broken. So, I mean, that is a criticism of using that approach and deciding whether or not the tie, isn't it? The ties.
That's not quite the same approach as the one I'm advocating. What Justice Leggett says there is there are many references to him having the question being whether his offending broke the social contract, which entitles him to the protection of the state. And if one goes back to the reasoning of the Upper Tribunal, you read that.
That's a narrower,
yeah.
Right.
Do
you see the grounds in this anyway? Well,
you may do that. There are quite a few issues.
It just issues in 26 just says.
Hopefully the submissions don't appear to be set out in the report, but
well, 34 is that? No,
no,
That's about lawful, isn't it? Is it?
Yes, exactly.
No, okay.
Help me on 79, please, because I'm trying to square that with. This is the suggestion that there's been double counting. The Upper Tribunal judge focused on the duration and seriousness of the criminal offending and the length of his prison sentences. He says seems to me potentially to involve double counting because that weighs in favour of the deportation. So what's the tribunal judge supposed to do then in order to work out the impact on the integration if he can't take into account the duration and seriousness?
So the judge can take into account the duration and seriousness. I think, with greatest respect, I think what Lord Justice Leggett is saying here is that, and this flows into the sort of breach of the social contract point. It sounds like what the Upper Tribunal was doing was in dealing with social and cultural integration, effectively putting more weight on the public interest in removal because of this break in the social contract.
I see.
And so it's sort of doubling up on that side of the scales. The reality, the correct approach in my submission is, of course, that the question of social and cultural integration is obviously a factor on the individual side of the scales. It's not that it obviously does play into the public interest in the removal. We know that from Section 117C1 and many other places, but it's relevant to, and that's really the beginning of Lord Justice Leggett's analysis here, where he explains how it plays into the question of private life.
You've got to read 79 with 80. Yes, I follow that.
Yes, exactly, my lady.
And in the light of your submission 77, the judge, Lord Justice Leggett says an erroneous approach taken by the Upper Tribunal judge. He should simply have asked whether, having regard to, etc., all those factors, he was at the time of the hearing socially and culturally integrated. So that looks, so it is a multifactorial evaluation, taking into account all those factors.
My submission on this passage, and it's quite an important passage,
yes,
is that one has to read that in the context of what Lord Justice Leggett has said before about the possibility of severing or weakening the private life side of the social, and the extent to which somebody is socially and culturally integrated. If one takes that out of context, then there is a danger that it reads as you just put it all in the mixing pot.
yes, but are you saying that in order for a tribunal decision to be safe from appeal, that the tribunal judge has to say at some point during the course of it, has the person's social integration been broken by, or been impacted by, or been, and actually look at it, almost going back to what I was saying before, temporally, as one would have said, and say yes, no, rather than an overall evaluation as to the balancing effect of these various factors.
What the judge does have to do is consider how the offending and any period of incarceration affect the social and cultural integration, and that requires a degree of consideration and explanation to show that the judge has in fact gone through that exercise.
But to me, that seems reasons rather than mandated approach.
Well, it's both, in the sense that you have to consider it and you have to explain your reasons for it.
Yes.
So you say if there's no clue in the judgment that the judge has considered, that might be lack of reasons, but you can't. You ought not to assume the judge has thought of it, just not given reasons. You assume he hasn't thought of it if there's no reasons given.
Yes.
If it's not addressed separately.
Yes, I mean, I'm very conscious of the fact that this court has, on many occasions, said that this is an appeal from a specialist tribunal.
Exactly, and you assume that they've taken into account everything they should have done. I think your point is much more fundamental than that, which is it is an evaluative exercise. It does involve taking into account all the factors pro and con. But in looking at the overall mix, it's got to be demonstrated that the judge has actively considered the extent, if any, to which the offending has impacted on social integration.
Yes.
That's all you're saying.
Yes, precisely.
And this judge didn't. That's your point.
Exactly.
Rightly or wrongly, that's your point.
Exactly. So I'm now taking the court to the paragraphs of the First-tier Tribunal that deal with this. I don't think I need to take the court back to them, but if it would assist, I'm obviously very happy to.
Just have a look. 154, isn't it? So he looks at the timing, looks at relationship.
And the extent of the offending is dealt with at 160 and 161.
So against you could be said, well, he's identified repeated offending as one of the factors, and he's weighed in the balance and decided it doesn't.
Well, but that's my point is that it's not a balancing exercise in that way. It's actually you have to consider the impact of
the offending,
the extent to which somebody's socially and culturally integrated. It's not a balancing exercise. This isn't a proportionality assessment. This is an assessment of whether somebody is, as a matter of fact, socially and culturally integrated.
So if he'd added a couple of sentences and said, I have considered the extent to which the findings in 159 and 160 impacted upon the establishment of his private life, and notwithstanding that they've had some impact, I've come to the conclusion that he has still socially and culturally established
The threshold is
sufficient.
met.
Yes,
Then that would be sufficient.
that would be fine.
Because my learned friend relies on it, there's just one further authority that I just need to deal with on this, and that's SC Jamaica. It's at tab 8, page 129 of the authorities bundle.
Yeah.
This was a case, Supreme Court decision, judgment of Lord Stevens. This was principally about the question to which whether or not the extent of somebody's offending is relevant to the question of internal relocation
yes.
for the purposes of asylum or protection other protection claims. But the court does consider there was an Article 8 claim in it.
That was another gang case, wasn't it?
This was. It may well have been.
I think it was a gang case.
It may well have been. The risk of persecution was said to arise from the fact that the appellant's mother was known to be a lesbian in Jamaica, and he would suffer persecution as a result.
It may have been the gang in Jamaica and not the gang over here.
The relevant paragraphs for present purposes are 51 to 52. In fact, directly for present purposes, 51. And what we see here is Lord Stevens, with whom the court agreed, approving the approach that Lord Justice Leggett set out.
Sorry, where are we?
Sorry, it's page 144 of the authorities bundle, 3205 to 34.
Yes.
And at the bottom of 144, we see that there's a brief consideration of social and cultural integration. We see paragraph 58 is set out of Lord Justice Leggett's judgment in CI. And then at the top of 145, he said, Lord Stevens says, I agree with the formulation of the question at paragraph 77 of CI, that a judge should simply ask whether, having regard to his upbringing, education, employment history, etc., the individual was at the time of the hearing socially and culturally integrated in the UK. Now, my learned friend understandably relies on that passage for essentially the points that the court was putting to me about that passage in relation to CI, as to whether or not simply it's a holistic multifactorial assessment. What I would say in response to that is there's nothing in this decision that indicates any sort of disapproval of the earlier parts of Lord Justice Leggett's judgment. And as I said, this passage has to be seen in the context in which it was said, and there's nothing in SC which, in my submission, undermines anything that I've said about SC so far. I accept, obviously, that it's not referred; those other passages are not referred to expressly. But if the Supreme Court were disapproving them, one would expect to see that expressly. And I appreciate this is perhaps of peripheral relevance, but of course this was one of the smaller issues in the case, if I can put it like that. So the court's sort of consideration of it was in the context of it being a case about several other issues.
I appreciate that, but it's also interesting seeing what Lord Justice Sales said in Kamara, as quoted in 52.
We'll come on to tomorrow in relation
know,
to.
But it's the same point, which is that it's a broad evaluative judgment, and so they do emphasise. They do that. Those two passages emphasise the broad evaluative nature of the exercise, and I think there's been a repeated caution about trying to be too prescriptive in saying this has to appear, that has to appear, you have to use these words or those words, because on the basis that it would just make the tribunal's judges
and I don't disagree
task harder and harder.
I don't disagree with any of that in principle. The difficulty is it can be how one then applies that in any individual case, and my submission is not that the judge made some glaring error of law of the type of thinking that offending was irrelevant or something like that. In relation to ground one, the point is, as my lady summarised it, that the judge simply had to deal with the offending in some way a bit more substantively than recording the fact of its existence.
Well, I think the problem, or one of the problems, is that you formulated it as a legal test challenge, but what's going through my mind, at least, is that it's really a reasons challenge, and you're not running a reasons challenge. But there is nothing on the face of this to indicate why he's reached the decision that he has. 161 is completely devoid of any proper reasoning, but you're not running a reasons challenge.
No, I suppose my submission is that the lack of reasons is indicative
Of the fact that he hasn't applied his mind.
Of the fact that he hasn't applied his mind to it.
Yeah.
And just to make good that point, obviously to make that bare submission comes up against the appellate approach. But in a case of this nature, where there was such persistent offending, serious offending, and what is, I would respectfully suggest, on any view, a relatively low level of social and cultural integration without the offending, it simply had to be something that he considered, whether that then meant that this case fell on the other side of the line.
Mm.
And I don't want to stray into making a perversity argument, but had he, and I accepted as your ladyship put to me, that had he gone on and said, I've considered whether there's a break, and I don't find that there is by virtue of the offending, that would have been an outcome that was open to the judge. But the point is that it had to be considered, and in fact, and if it had been considered, it would have been spelt out. It simply would have had to have been.
Do you make a sort of temporal point here then, that on the evidence, until 2015, there's no evidence of criminality? Is that right? The FTT's criminal history with that one starts.
It's not full. No, it's not full. There was offending in 2014.
Right.
That's one of the reasons I wanted to see the PNC.
So the first offending, there's a reprimand for criminal damage in 2008.
No, I see that the PNC has much more. It's just that the FTT don't record anything before 2015, I think.
So
I think they've just gone for the things that caused him to go to prison.
I think that's right. I think his first sentence of imprisonment was 2014. I think that's where the chronology effectively starts. It may be that that's what the Secretary of State's decision letter also did, so it may be that that's the reason. But in fact, there is evidence of criminality going back further than that.
And is that simply not taken account of then in this decision? The criminality before?
I suspect not. I mean, that's not my ground. So I maybe it ought to have been, but it isn't a point I'm taking.
You've got community order for burglary in 2011. Criminal damage 2013. Criminal damage again 2014. Conditional discharge. Theft, shoplifting. Bladed article, that I think certainly was referred to at some point.
So there are
So
there is quite
2014
there are a number of bladed
bladed
articles.
articles. And there was a suspended sentence for abusive, insulting, etc. behaviour of 2014. This thinking skills programme and a curfew requirement for a tag. And he gets another suspended sentence. I mean, it's a much more complete picture of his offending
is.
behaviour.
One thing I would just say
Is
in
it
answer
not
to-
within your ground?
Sorry?
Is it not within your ground? Your ground is
Well-
the judge failed to have regard to the impact of criminality on.
One of the difficulties, just sorry, rings a bell that possibly should have rung sooner. If one looks at the documents that the judge records he had, sorry, page 98 at the very bottom, he records that he had the appellant's PNC. Now, obviously, it's not as up to date as the one that I handed up today,
No,
but
I wonder if I may say, paragraph 23 of the FTT's determination.
Yes, thank you. 19 convictions for 34 offences. Yes, thank you.
and to be clear, my submission isn't that the judge was unaware of the offending.
No,
It's
okay.
the analysis that he undertook in relation to how it impacted and didn't impact the appellant's social and cultural integration.
but to describe it as, in a rather bland way, as a checkered adult life involving periods of homelessness and repeated offending is a bit of an understatement.
Well, it is. I mean, I think in fairness, he's quoting the Mr. Dabo's counsel's
Yeah.
the way she put it, but in the skeleton argument. But
Yes.
I mean, I agree with your ladyship that I think that's possibly not how one would objectively describe it.
No.
I think unless the court has any further questions on ground one, that probably is sufficient to deal with my submissions on ground one. Ground three deals with the tribunal's treatment of the very significant obstacles to integration in the country of nationality under section 117C 4C. The authorities here, I think the easiest place to take this might be your ladyship's judgment in ACON, which is the very back of the authorities bundle. It starts on page 210.
Yes.
And it's paragraph 23, on page 216. Your ladyship will correct me, but I read this as effectively just summarising what has been said
In
in
Kamara.
well, and in Pardine.
Yeah.
So, in particular, if one starts at halfway through that paragraph, one sees in Parveen, or Justice.
Sorry, which paragraph?
Sorry, it's paragraph 23, my lord, and top of 216. In Parveen, Lord Justice Tribunal referred at 9 to Kamara, rightly noted that the passage in Lord Justice Sale's judgment focuses more on the concept of integration rather than what's meant by very significant obstacles. And I mean, that's really the key distinction for present purposes. And considered the observations made in Bowen and said it's fair enough to observe that the word very significant connotes an elevated threshold. I know, of course, the observation that tests will not be met by mere inconvenience or upheaval. I'm not sure that there are, by saying that mere hardship or difficulty or hurdles, even if multiplied, will not generally suffice, which is what the tribunal had said in Bowen, adds anything of substance. The task for the tribunal in any given case is to assess the obstacle of consideration relied on, whether characterised as hardship or difficulty or anything else, and to decide whether they regard them as very significant, obviously applying that elevated threshold. If we turn back, please, to the First-tier Tribunal decision, at page 173,
Paragraph.
Probably, yes, I suspect what paragraph 173. So let's start at 162, actually, if we might. Page 118.
Yes.
The self-direction that the tribunal gave itself was to remind itself of Camara, which, as said by Justice Underhill in Carving, focuses on the integration aspect of very significant obstacles to integration. We then have the judge's assessment of relevant evidence as to what difficulties might be faced by somebody who is without family in Guinea. And then at the end of page 1, the reasoning then is at 173 and 174, and the judge makes crystal clear that what he's doing is applying Camara and making a broad evaluative judgment. I find on the balance of probabilities that it will not be enough of an insider so as to have a reasonable opportunity to be accepted there and be able to operate on a day-to-day basis. I find that there will be very significant obstacles to his reintegration into life in Guinea. And my submission is I hope, a simple one, namely that the judge directs himself to the concept of integration, but not as to the elevated threshold in relation to this question. There are references to the elevated threshold in relation to 117C6, but not in relation to the very significant obstacle test. And there's simply nothing to say, well, I find that he won't be enough of an insider on the balance of probabilities. Are the obstacles that he faces sufficient to meet the elevated threshold to very significant obstacles?
Well, insider again is part and parcel of the integration side of the test. As Lord Sales, the idea of integration calls for a broad evaluative judgment to be made as to whether the individual be enough of an insider in terms of understanding how life in society is carried on and a capacity to participate in it, so as to have a reasonable opportunity to be accepted there and operate on a day-to-day basis.
Those are Lord Justice Sales' words from Camara.
Yes.
And it's clear that 173 is, he's doing what he's saying he's doing, which is applying Camara, and I would add only Camara. What he's not doing is considering whether the elevated threshold has been met. Now, as I understand my learned friend's position, it's that in finding in 174 that there will be very significant obstacles to reintegration, that is sufficient.
Well, no, of course not. But with respect, of course it's not. The question is whether he's done both sides of it in adumbrating the points that he has before. So he's identifying what the obstacles to integration are. Never lived in an adult, no supporting family, family support and kinship is an important aspect of life in Guinea.
Yeah.
So he's got none of that, and he hasn't gone through any of the traditional rites of passages. And there is a fear that he might become destitute. Nothing in relation to any other sort of support that he might get if he goes back. I don't know what was put on the other side of the line, but I mean, isn't that generally sort of portraying the fact that he's got nobody to support him, and he needs somebody to support him because of the way that traditional life in Guinea is lived, and that provides a very significant obstacle.
So I'm not running a perversity challenge. I'm not saying that he couldn't, on these facts, have found that there were very significant obstacles. My point is that he's gone through what the obstacles are, but then assessed whether that prevents a degree of whether there's the integration aspect of it. But there's just absolutely no consideration as to whether the threshold, the elevated threshold that the case law makes clear is required, is met. Whether
it's more than mere inconvenience or upheaval.
Exactly. The degree to which the he identifies the obstacles. What
Yes.
he doesn't do is assess which side of the line, assess rather than conclude which side of the line it's on.
Right.
How would he have done that?
If he had said, the authorities established that the threshold is a high one, mere
Yes.
hardship is not sufficient. Having considered the obstacles that have been identified above, I'm satisfied that they cross the threshold into being very
So
significant.
simply a sentence saying, I'm aware that it's a high threshold. The high threshold comes through the words very significant.
Yes.
So in using the words very significant, doesn't that demonstrate that he was aware that the obstacles needed to be very significant?
So I think the fact that there's been numerous cases about the meaning of the word very significant
He could not,
means that it's a little bit difficult to just assume that the right test has been applied
really.
by virtue of the use of the statutory wording. Now, I'm not saying that necessarily follows that. But
Isn't that precisely what Lord Justice Underhill said the tribunal should do? Forgetting the gloss that is unhelpful from other cases, just ask yourself, assess the factors and ask yourself whether they are very significant.
yes, but the point is not about explaining the law. My point is about whether or not. There's no consideration as to why it falls on one side of the line or other.
So it's a reasons challenge again.
It's the lack of reasons is demonstrative of him not having.
But you see,
Like
I
that.
mean, again, thinking of other authorities that have said it can be quite difficult to articulate. You know, you don't say, well, this, you can't say this is, well, this is why. I mean, it doesn't, it's not susceptible of that sort of analysis or approach. You set out in your decision the elements, the factors that lead you to your conclusion. And so, as my lady says, that he set out in the previous paragraphs the factors that, in his assessment, lead to the conclusion that there are very significant obstacles, including because effectively he won't be able to integrate. He will not be enough of an insider so as to have a reasonable opportunity. So I mean, he's saying he won't effectively won't be able to integrate at all.
So in my submission, there are effectively three stages to the analysis. I
Yes.
appreciate these aren't necessarily. These will be the usual three stages. I'm not suggesting that they're sort of necessarily required,
Right.
but
Yes.
just as a matter of kind of analysis, one has to identify what the obstacles are. Now,
Yes.
those are usually done by the individual. Assess whether or not they are made out as on the facts.
Yes.
And that I don't criticise. The judge has obviously done that. One then has to assess the degree to which those obstacles affect integration, and that's the Kamara aspect. And then one then has to also consider whether or not those obstacles to integration are very significant. And I don't say that the judge has to have done very much to demonstrate this, but the judge simply states a conclusion at 174. There's actually no reasoning as to whether or not that threshold is surpassed. And in my submission, the fact that the judge hasn't undertaken any analysis as to whether the threshold is surpassed is an error. And that's not itself a reasons challenge. It's a failure to consider the relevant legal question.
So the judge has to do it in stages to pass this test. He has to set out, he or she has to set out.
I don't want to be over prescriptive about it because provided the judge has done it in substance, there's no problem with it. But my submission is that there's nothing in the judge's judgment to indicate that what I see as the third stage. I don't really care whether it comes first, second, or third, but that third stage was ever engaged with, or I don't really like the phrase engaged with, but whether the judge just hasn't considered that question.
And the difference between this case and ACOM was, of course, that it was a reasons challenge, and in ACOM, and I'm just looking to remind myself the conclusion at paragraph 49 on page 222. That there was no demonstration by any reference to any specific passages in the decision that the judge had in substance addressed whether the obstacles she'd identified would prevent or seriously inhibit this person from integrating into the society. Prevent or seriously inhibit. Well, in this case, I fear that he will become destitute. He'll be seen as a dependent male. He won't have any sort of family support, etc. I mean, can't it be inferred from all of that the judge has explained it?
So my submission is no. That's all going to the nature of the obstacles that are relied on and assessing what they are. And in my submission is simply that in then considering whether the statutory threshold is met, the judge had to at least give some indication of why he thought it was. And that, I appreciate I just expressed it as though it's a reason challenge, but in my submission, the absence of any analysis in respect of which side of the line these fall on is indicative of a failure to ask itself, for the tribunal to ask itself the right question. I accept entirely, I mean, this is a case where I accept that it's not perverse for the judge to come to this conclusion. It's not a perversity challenge, and I accept that all of the matters to which relationships just referred are matters which might have tipped the balance, but that's not. And I appreciate that you may make a different point to that, but my submission is just simply there's an absence of analysis, and that analysis was required by the statutory test.
Thank you.
Unless your worship any further questions, I think it might be worth just touching on relief.
Yes.
Just as we always forget it. I do anyway. Because this is a perversity challenge, this would have to go back.
Yes.
I suspect, given the passage of time, it makes more sense for it to go back to the First-tier Tribunal for a de novo appeal in respect of Article 8.
Yes.
Obviously, all the asylum stuff hasn't been appealed, so that
No.
would be preserved.
Yeah. Okay.
But that would be my submission on relief.
Thank you. Yes, Mr. Saeed.
Thank you. The court will have heard my slight discomfort at a PNC being whipped out at the last moment. I hadn't been even put on notice.
I understand that.
Yes.
I think, though, that the fact that the PNC, obviously, to that date, was in front of the First-tier Tribunal, and we're clearly entitled to see the relevant entries in the PNC up to that date, and it helps give greater substance to the history, or greater sort of concrete analysis of the history. Yes, okay.
Yes. So the structure of my submissions is that I'm also going to touch briefly on some key factual findings made by the FTT, which are not the subject of any challenge, but which do underwrite some of the judge's conclusions on the two issues which are in contention in this appeal. I will also touch on some of the core authorities that you've already been taken to by my learned friend. If I may conduct something of a whistle-stop tour of the FTT's determination,
Yes.
and indeed some of the factual history, if we go right to the beginning, paragraphs 4 and 5, this is core bundle 97.
Yes.
The court will see that Mr. Dabo arrived in the UK on the 4th of March 2007. He was 16 years old. As we've heard, he had leave all the way up until October of 2011, covered initially by the grant of leave he was given up until the age of 18, and thereafter while his appeal proceedings were pending. In fact, 2011 is when he becomes unlawfully present in the UK, is the moment from which we see some of the criminal, what we see the beginning of the PNC offences. The deportation order which gave rise to these proceedings was made on the 6th of August of 2018. following the index offence, and the respondent brought an appeal on refugee and human rights grounds. The reason why it took from 2018 to 2023 for the FTT to promulgate its determination is that there was a round of FTT and Upper Tribunal proceedings first. He appealed to the First-tier Tribunal on asylum and human rights grounds. That was dismissed. It went to the Upper Tribunal. Error of law set aside, back to the FTT. Now, the significance of the timeline I've given the court is that actually when we come on to look at factual findings in respect of his asylum claim, it's only 16 years after his arrival as a 16-year-old that the core of his asylum claim is first believed. And I will take you to those passages in the determination. If we jump forward to paragraph 54, so this is in the asylum section of the determination, which is a significant chunk of the determination.
Yes.
If we go to paragraph 54, this is page 104, you'll see reference to supporting the appellant's account of being tortured. If we then jump to paragraph 62, we see, that's page 105, we see reference to the psychiatrist's conclusion that his significant mental health problems are consistent with his accounts of mistreatment and torture. And then paragraph 70, you'll see the FTT judge's conclusion on the effect of the expert psychiatric and psychological evidence. And then if we jump again forward to 98, you'll see what the judge finds in respect of what happened to the respondent. In short, the judge accepts that he was arrested, detained and tortured in 2007. His father was murdered.
Is there a finding that his father was murdered?
I think, yes. Para 101.
Finding that he was killed.
Yes, I mean, I think the account given is that
It's been consistent about it.
yes. Now the judge goes on at paragraph 102 in quite a lengthy assessment to conclude that 16 years after these events, there is no current risk on return. But those crystallised factual findings in respect to the asylum claim, which was ultimately dismissed, are then carried forward and have relevance within, at the very least, the very significant obstacles to integration point. And the judge adopts those findings. The point I'm making is that this is a very lengthy...
He could relocate, wasn't that?
My lady,
Am I wrong?
I didn't quite catch
I
that.
thought there was a finding he could relocate.
No, the finding was that the finding on risk
First
of...
decision.
Yes, yes. The judge's conclusions...
Judge says, I don't accept the basis on which he finds that the appellants will be at risk. Find that he was a low-level member of the UTSG.
Yes.
No credible evidence 16 years later he'd be at risk in relation to Guinea. His assertion to the contrary is found to be fanciful. So no finding risk on return. Right. So the previous tribunal had decided that he could relocate, but this tribunal decides that there's no risk anyway.
Yes, there's no extant risk. I draw the court's attention to this, as I said, because it then feeds in. But my point is this is a lengthy determination running across some 30 pages, across 214 paragraphs, and there are a number of sections. The asylum claim. Within the asylum claim, there is the historical, Devasilian, and sometimes factual findings and observations are borrowed in other parts. This determination is long enough, and for example, when we come to look at the two issues in contention, I will be submitting that there are aspects of the judge's findings and conclusions and observations found in other parts of the determination, which demonstrate that the judge had in mind the appropriate tests and had in mind relevant factors to the application of those tests. If I could just make my overarching submission first before coming on to the two grounds of appeal. Our submission, the court will see in our skeleton argument, is that this is actually a model of how the FTT should determine cases of this nature. At paragraphs 25 to 34 of our skeleton argument, which can be found in the core bundle at page 38, we have set out at some length all of the key relevant passages about the appellate approach to reviewing determinations at first instance. There are a series of them. The court will be well familiar with those principles, and I don't intend to take the court through those. And indeed, those passages are agreed between the parties, subject to a slight caveat from the Secretary of State. But obviously, we ask that the court has those passages closely in mind when assessing the Secretary of State's criticisms of the FTT's determination. But I have 5 points in my overarching submission as follows. The first is that we submit that the FTT cited and applied all the correct legal tests and the necessary authorities. We say that there is no discernible misdirection of law on the two issues which are before this court. The second point is that the extent to which the FTT judge dealt with the evidence and the principal controversial issues was sufficient. The third point we make is that...
Hold on. Sorry, the extent to which dealt with the evidence and the principal...
controversial issues was sufficient.
Yes.
The third overarching submission is that the FTT's determination and the reasons given for the conclusions reached within it were intelligible and adequate. The losing party, in this case the Secretary of State, is not left in any doubt as to why she did lose. The fourth point is that when judged against the standards set by the higher courts for appellate intervention, when read fairly, and by that I mean without being hypercritical, and when read as a whole, the FTT's determination is legally unimpeachable. And the final point in our overarching submission is that in reality, the Secretary of State's grounds are nothing more than an expression of her dissatisfaction with the judge's conclusions, repackaged as errors of law.
Just a matter of interest, do we know whether the First-tier Tribunal judge was referred to Bin Buga? The so much reliance is now being placed on it.
I don't understand that to have occurred. I didn't appear below.
No.
But see, I know one of the points we make is that actually Bin Buga has a very narrow ratio, and indeed, to the extent necessary, the Court of Appeal in CI Nigeria, which is, I think, widely regarded as the leading authority on how social and cultural integration more broadly is looked at, with a specific focus, amongst other things, on how criminal offending and periods of imprisonment. But the answer is, I don't think there was any reference.
I don't know. I'm afraid I haven't seen any evidence one way or the other.
I mean, had it been relied on, it may well have been relied on by the Secretary of State for the Home Department, but I don't understand that it was. Before addressing grounds 1 and 2, I mean, contextually, it's important to acknowledge what the Secretary of State is not challenging. So no challenge to the FTT's treatment of the evidence and the resulting factual findings. No challenge to the weight, so this is the second one, no challenge to the weight accorded by the FTT to the public interest in the respondent's determination, deportation. And the third thing that the Secretary of State is not challenging, and I think it's of particular note, is that there is no freestanding challenge to the FTT's application and evaluation of the very compelling circumstances test. Of course, I acknowledge that significant components of that evaluation were the judge's conclusions on social and cultural integration and very significant obstacles. We know that that's the approach in LA Pakistan.
If one goes, then you've got to
Yes.
reevaluate the whole thing.
Yes.
So if ground one were to succeed, it would have to go back for a reevaluation, wouldn't it?
Of course, my lady's quite correct. It would infect the very
It would
compelling
infect the very compelling
But the
circumstances.
Secretary of State is not asserting that even if her two grounds attacking the two conclusions do not succeed, there is nonetheless legal error in the approach or reasons given by the judge. And one very often sees them paired up. And so if I now could turn to ground one, and looking at the FTT's determination, we will see that at paragraph 153, page 117 of the core bundle, as far as social integration is concerned, I remind myself of CI Nigeria. As I said, that is the leading authority on that test. The question is, does the judge need to do more? Does the judge need to unpack CI Nigeria, provide some extensive quotes from it?
No, he just needs to apply what was said in it
Yes.
properly.
Okay, we will come to that. The Secretary of State's case on ground one is headed failure to apply bin Booger. And indeed, it seems that in my learned friend's submissions today, things have moved on slightly, which are, it appears to be a failure to apply CI Nigeria. CI
Are you saying
Nigeria.
the two are inconsistent with each other?
I don't say they're inconsistent with each other, but the extent to which Bimbuga, the ratio of Bimbuga, we say is very narrow, confined as it is to specifically how gang membership may impact whether a foreign criminal is socially.
Bimbuga goes wider than that. Bimbuga is about whether or not you treat involvement in antisocial behaviour as social integration. That's what it decides you don't do.
If we just pull up Bimbuga, then.
Do you disagree with that assertion?
Bimbuga, if we just pull up, I will come to Marlene's question in a moment.
No, I'm just intrigued as to whether or not you disagree that that's what it decides.
If we go to paragraphs 55 to 60, I think are probably the operative paragraphs. The legal error was clearly on the part of the FTT in the positive reliance upon gang membership. Paragraphs 57 and 58 are clearly important observations, which say, I think 57 and 58 could be read as saying, even if you're not a member of a gang, but you have been involved in criminal activity and have a criminal lifestyle, that will be part of the analysis. It will be part of the assessment of whether or not you are socially and culturally integrated. So to that extent, absolutely, it is consistent that there is no
with CI Nigeria.
there is no inconsistency. So in truth, it turns out that the real battleground, as it were, on this ground of appeal is CI Nigeria rather than Bimbuga. In a sense, Bimbuga may be something of a red herring. So if we could turn to CI Nigeria. And and I just want to go to starting at paragraph 57, which can be found at page 99 of the Authorities Bundle 6. Obviously, as far as the consideration of deportation appeals, really since 2014, have now been, the Article 8 considerations are housed in a statutory framework. But it's important not to lose sight of what the phrase social and cultural integration means. Because paragraph 57 of Lord Justice Legate's judgment, in assessing whether a foreign criminal is socially and culturally integrated in the UK, it's important to keep in mind that the rationale behind the test is to determine whether the person concerned has established a private life in the UK, which has a substantial claim to protection under Article 8. As distinct from Article 8 family life, which has a number of clear, bright lines, family life either does or doesn't exist. Private life is a slightly more textured picture. It's about...
Everyone has a private life.
Yes.
The question is it an established private life of the type that one has to protect?
Quite. And so there is a threshold in there which has a substantial claim to protection under Article 8. And paragraph 58, Lord Justice Legate then does set out that actually it's quite an impressionistic assessment, as well as particular ties and particular actions and particular qualifications and relationships. There is the notion of identity, social identity, language idioms, local knowledge are also part of that. They are part of the picture, and of course the passage of time. A person who arrives in the UK at the age of 16 commits a very serious offence of the type the respondent committed within a year or two of arriving. The development of their private life will be significantly smaller, as it were, than the private life developed by someone who's been in the UK for a significantly longer period of time. So actually the passage of time is a significant aspect of the formation of a private life.
The client started offending about 3 years after he arrived.
Yes, yes.
So what we get is a period of social integration for the first 3 years, during which time he's got immigration status, and therefore that will help because he's able to work and so on and so forth. And then a very sad picture, if I may say so, of what appears to have been a decline partly brought on by alcohol dependency, partly by drugs, and drifting in and out of homelessness, thereafter no work at all, an on-off relationship with a girlfriend, which I think was more off than on until after 2019, and very little evidence of any form of social integration whatsoever. That's the overall picture that we're faced with.
Yes, I mean, and I do think the judge squarely had that in mind.
Well, that's the real question,
Yes,
isn't it?
yes.
I mean, it doesn't. Reading the decision, that picture does not come across as loudly and clearly as it does when you actually read the evidence. Being frank.
Yeah, it is correct to state that the passage on social and cultural integration in the judge's determination is relatively short. But
To be upfront with you, my real concern is paragraph 160. Paragraph 160 is not the sort of balancing exercise that one would expect to see in a proper evaluation of social integration. He puts all the plus points down, one after another, lists them, that's all fine, and some of the minus points are included. But I find nothing in this which specifically says at any stage there was a period of integration where he seems to have led a completely blameless life and then he went off the rails completely. And I have to take all of that into account in determining how far he's integrated into the country. If he'd done that, I doubt if we'd be here. But paragraph 160 is causing me some disquiet.
My lady, if I might take you to some other parts of the determination in which the judge does acknowledge the extent of his.
Have you finished? You were taking us to CI Nigeria. Do you want to finish with
Yes,
that first?
let me go back to CI Nigeria and we can return. I was making some points about how a private life is constructed, because one of the questions is, well, can you lose a private life? Can it be extinguished? Can it be severed? Is this notion, this temporal notion of loss or acquisition?
Yes.
And if we jump forward to paragraph 61 and 62 of CI Nigeria, the court will see halfway down paragraph 61. Periods of imprisonment represent time excluded from society, which the prisoner has little opportunity to develop social and cultural ties, and may weaken or sever previously established ties.
It's weaken or sever ties,
Yes.
not weaken or sever integration per se.
Yes.
So it's so to elevate that as though you're looking at whether or not integration, I think, is a false comparative, and I think that was speaking for myself one of the reasons I found difficulties with aspects of Mr. Skinner's submissions. You're looking at the ties for the purposes of determining their impact.
Yes.
But as my lady says, sorry, go on. Yes.
Yeah.
Go on.
And if we go on to paragraph 100 to 62,
Yes.
6 or 7 lines up from the bottom, it is hard to see how criminal offending and imprisonment could ordinarily by themselves, and unless associated with the breakdown of relationships, destroy the social and cultural integration of someone whose entire social identity has been formed in the UK. This was a case of someone who arrived as a child. The respondent in this appeal arrived at the age of 16 and then has been in the UK for now approaching the best part of 20 years. But if we jump forward...
Exactly, because the reason being is that you're looking at, to use the same word, ties.
Yes. Yes, my lord, that's correct.
It's really, it's what to use the vernacular sometimes is used as we call somebody like a homegrown criminal, I think is the phrase that you sometimes see in cases, because they've been here for so long that frankly it's no different. If they've come here as a baby, it's no different from if they've been born here. They're as much integrated as if they were born here, and therefore you can't say, well, simply because they've gone off the rails as a teenager and joined a gang and done various horrible things as a result of that they're not integrated. And that's the point that Lord Leggett is making.
I think that's right, my lady. There's a starting gun that starts on private life, and it's different depending on when you arrived. Had the respondent arrived when he was 12, maybe his private life would have been a bit deeper. He still arrived as a child. And by the time the tribunal was considering it in 2023, he'd been present for 60 years. If we could jump forward to paragraph 75 of CI Nigeria.
Sorry, say it again.
Paragraph 75 of CI Nigeria.
Yes. Yes.
The opening words of 75, I'm sure that the Upper Tribunal was right to say that social and cultural integration in the UK can be broken by criminal offending, but ultimately it's an entirely fact-sensitive question. And our submission is that after all is said and done about an evaluation of the effect of criminal offending and time spent in prison and how it might impact on what is quite a kind of textured and impressionistic picture of how one quantifies whether someone has a private life worthy of protection. Actually, the bottom line, we say, is that paragraph 77 of Lord Justice Leggett's judgment is the bottom line. That is the task of an immigration judge. And the history of criminal offending and imprisonment, of course, is relevant. And as a fact-sensitive analysis, if there were, for example, evidence that someone had spent effectively 10 or 12 years back-to-back in prison, then that may, on the particular facts of a given case, there may be a complete severing of ties. Indeed, you know, a dissolution of an existing private life. But it is entirely fact-sensitive, and I don't think it was ever looking at the PNC and looking at the history of offending. Actually, there have been periods where there haven't been offending, and I think the judge in our submission was entitled to take a view on whether or not applying CI Nigeria, whether overall there was a private life worth protecting, whether there was social and cultural integration. Paragraph 79 of CI Nigeria, in a sense, it is a note of caution. It cautions everyone, really, FTT judges and appellate courts from straying into a debate about the public interest. That's a different task, and you know, one finds that before you know it, you're deep in the PNC and you're looking at, you know, how serious offending was, and actually that comes later. That comes as a freestanding part of the balancing exercise. That's not a part of this.
The real question is, what's the strength of his private life claim, isn't it?
Yes.
That's the context in which you're evaluating social and personal integration, because you're trying to say how strong a personal life claim, a private life claim has he got? Because in order to be able to tell whether removing him is going to be a disproportionate interference with that private life, you've got to evaluate the nature of the private life in the first place.
That's quite. It must be weighed before we can determine whether it's displaced by a. It has to be evaluated to see its depth and strength. I don't disagree with anything that my lady has said there about the approach. If we return to the FTT's determination, there's no doubt that the FTT going to this point of social and cultural integration and the impact that offending and imprisonment has had on it, there can be no doubt that the FTT had the respondent's offending at the forefront of its mind. I mean, there's frequent reference throughout the determination, and I'm going to give you those paragraph references. For example, paragraph. If we start at paragraph, you'll see the opening passages, paragraphs 6 and 7. Just a very short history there. Paragraph 23, acknowledging the number of offences, referencing the updated PNC. I think there was an updated PNC that was put before the remitted FTT appeal, bringing it all up to date. Paragraph 160, and I'll return to 160 and 161 in a moment. That's contained within the social and cultural integration. If we jump forward to paragraph 187, this is now in the very compelling circumstances proportionality assessment. You'll see 187 and 188. So a recognition that the respondent has committed a number of serious crimes, one in particular, the index offence, but also has a number of other criminal offences, including time spent in prison. Paragraph 202 you'll see that's an important capturing of the nature of my client's offending history. Now, it might be said that every time criminal offending is relevant in a determination, so for example, social cultural integration, weighing of the public interest, conducting the proportionality exercise, the judge, we submit, doesn't need to remind himself at every juncture. I remind myself that this.
No, if at some earlier stage it had been said, by way of background, he led an entirely blameless existence up to 2011, was engaged in lawful employment and had a girlfriend. Then he went off the rails, I use the vernacular, in 2011 and drifted into homelessness, alcohol and drug dependency and a criminal lifestyle. The fact that that's not repeated at a later stage, it would make your point for you. Trouble is, there's nothing to indicate that that picture has had any bearing on the evaluation of integration at the appropriate juncture. All we've got is para 160, which says absolutely nothing.
Paragraph 160.
Sorry, not 160. What is it? 180. It's
The checkered adult life.
Yes, that one.
Yes. My submission in respect of that is that if one reads para 153 to 161 as a whole, my lady is correct. The judge does make a series of observations / factual findings about the positive aspects, if I can put them that way, that establish private life. Of course, the centrepiece of that is the opening lines of para 154, where the judge says, well, this appellant entered the UK at the age of 17. He was in fact 16. Yeah, when he was still a minor, and he's lived here ever since. There's an on and off relationship with a girlfriend. You'll see at para 146 and 147 at the top of that page, when the judge is considering the family life exception, there was a witness statement from the on-off girlfriend. She did not attend the hearing. The judge concludes, well, this doesn't amount to family life within the meaning of Article 8. But clearly, when you get to paragraph 154, the judge, and 155, the judge is saying, well, actually, this is part of the picture of private life. Para 157 and 155.
Please, the date of the tribunal decision.
The date of the determination is the 18th of August of 2023.
Four-year relationship, or four-year resumed relationship.
Yes. And at paragraph 160 to 161, a checkered adult life involving periods of homelessness and repeated offending is really a real shorthand we submit for what was clear before the judge in the form of the PNC and acknowledged in other parts of the determination, that there has been, as the judge says, a litany of offences. He's had a checkered adult life. And if we look at paragraph 161, the opening word of paragraph 161 is nonetheless. When I take all these factors into account, the nonetheless is a reference to the criminal behaviour and the criminal offending. And we say that para 153 to 161 is relatively short. We submit that the judge was familiar with CI Nigeria. There's a series of authorities cited at paragraphs 25 to 34 of our skeleton, in which this court, on a number of occasions, has said judges there should be extensive quotes. If they have identified the appropriate case, they should be presumed to understand what is in it. And it goes back to my overarching submission. Actually, when one takes a step back, takes a panoramic view of this determination, looks at a judge who has had multiple issues that he had to deal with, he has structured a determination in the way that he feels is proportionate in terms of its length, but dealing with all of the issues. And actually, my submission is that when one looks at 153 to 161 of the determination and views it through the lens of paragraph 77 of Lord Justice Legate's judgment in CI Nigeria, the judge has the judge's discharge of his function under section 117 section 117C 4A. That is sufficient. If I could just take the court briefly to SC Jamaica, which my learned friend did
Yes.
take the court to, paragraph 51.
Hold on. Yes.
You say that's an endorsement by the Supreme Court of the approach of Lord Justice Legate.
Yes, but actually, paragraph 51, as far as the evaluation of the test under 117C4B is concerned, actually, Lord Stephen's opening observation is that it's to be determined in accordance with common sense. And there is undoubtedly
that one too far.
There's undoubtedly a temptation on, in a sense, both on the Secretary of State's part and on deportees who are appealing to this court to seek to erect tests within tests. But actually, and it's never ending. A judge never quite does enough, whichever side of the aisle you're on. But actually, we submit that as a matter of principle and as a question of law, there is unbroken and consistent authority about how this court, appellate courts, should view FTT's determination, and they must be given a benevolent reading. The judge has done, it might be said, a very good job, but he could have done better. But
that's not good enough, you say.
Yes.
As long as he ticked all the boxes, that's fine.
Yes. And actually, Lord Stevens, on page 145, yes, in the end, Lord Stevens adopts the formulation in paragraph 77. And in the end, it is a multifactorial assessment. You take a holistic view of it because we're dealing with private life, not family life. The significance of your criminality and has its place later down the line in the proportionality assessment.
Private life is usually a much harder basis on which to resist deportation than family life. That's the way that it usually operates.
That is correct, and that's captured in the statute. Private life established at a time when you're not here lawfully should be given less weight than, and the judge expressly acknowledges that.
Pretty great.
Yes. That's in his proportionality assessment, paragraph 184.
As you rightly say, that comes in at a later stage of the analysis, not at the stage of integration.
Yes. Now, I mean, there are passages in the judge's quite detailed proportionality assessment which could have been housed in earlier parts of the determination, and maybe we would have been more satisfied had the judge acknowledged this is a man with a litany of offences who spent a significant time in prison. However, taking everything into account, I find that he has a level of social and cultural integration. Let's move on to the next issue. I've got 3 or 4 more to get through here. So I would caution the court to not to become, as it were, as the Secretary of State's case has done, fixated on a small passage and then pore over it and say, well, this could have been better. And had you simply said this, then you would have been fine. But actually, it's the panoramic view of the determination, which I submit is an important component in assessing whether or not legal error has or has not been committed. I know it's not the usual course in these sorts of proceedings to dwell on what the upper tribunal may or may not have said. I would just invite the court to look at paragraph 22 of the upper tribunal's decision. That's at page 69 of the core bundle. And then 23 as well.
Well, the case that was being run before then was a somewhat different one. It was a rationality challenge.
Yes. I mean, without being impolite, the grounds of appeal from the FTT to the upper tribunal were there was something of a they had a kitchen sink feel about them, and I think often almost everything is thrown. But actually, if one looks at 22, well, indeed, if one looks at 21, one sees how the Secretary of State puts it before the upper tribunal. The judge did not consider whether his integration had been broken by his offending. That was certainly a component of the case before the upper tribunal, and that is rejected. And actually,
where is that?
If one looks at paragraph 21, the appellant, the Secretary of State in the upper tribunal.
Yes, I see. Got it. Thank you.
So my submission is that when one the ultimate formulation of the test is that contained in paragraph 77 of CI Nigeria. It is approved in SC Jamaica by Lord Stevens. We submit that the judge was aware and cited CI Nigeria, recognising it as the authoritative decision. And paragraphs 153 to 161 were a legally adequate evaluative assessment of social and cultural integration. And actually, to impose any greater requirement on a first-tier tribunal judge to do more than just acknowledge the leading case and to conduct a holistic evaluative assessment, to suggest that what we have here is insufficient to shield it from legal error, my submission would not be the correct approach in the light of the authorities.
If we just get back to SC for a moment, you took us to. Sorry, I lost it.
Yes, page 144 of the authorities bundle.
Thank you. 144. What I was trying to just look at was the specific, because I've noticed that 106 has been sidelined as well.
Yes, 106.
And in 106, the submission made on behalf of the Secretary of State was that the first-tier tribunal judge had failed to pay adequate regard to SC's membership of criminal gangs in reliance on Bin Bouga was rejected.
Yes.
On the basis that the FT judge was aware of and specifically considered SC's criminality and his previous gang membership in the context of. And I was, having considered those factors, she was entitled to conclude. And I was just wondering, I was just trying to see whether there was anything in the decision which indicated how the first-tier tribunal judge had considered that aspect in respect to social integration. it's really 152 at the top of 152. Obviously, then it was through the immigration rules. B, paragraph 46. I think that's yes of the FTT decision. Lived in the UK since 10. Attended school. No contact with anyone in Jamaica. His offending did not indicate a lack of social integration. Accordingly, he was socially and culturally integrated.
My lord, might I just ask for that paragraph reference in this?
Sorry, it's page 152, and then it's in paragraph 82, but it's at little b at the top of page 152.
Yeah. I will in a moment, probably towards the end of my submissions, take the court to the decision of Lord Justice Popplewell and AA Nigeria about this idea of this infinite number of factual permutations and fact-sensitive cases, and the notion that the Court of Appeal is not here to produce conformity of decision making on particular factual matrices, and actually. In a sense,
that's been specifically eschewed in cases such as Kamara. It's very much a fact-sensitive case. Each case depends very much on its own facts. You don't need. You're pushing at an open door on that one.
So in conclusion, my submission is that paragraphs 153 to 161 reviewed against a test which provides judges with quite a lot of discretion as to how they conduct that broad evaluative assessment, is a conclusion that we submit the judge was perfectly entitled to reach on the evidence, having had the benefit of conducting the first instance trial, and is entirely in keeping with paragraph 77 of CI Nigeria, and on that basis. We would submit that there is no legal error there. We would ask that the court dismiss the Secretary of State's ground 1. I shall move on to ground 2.
And 3.
Sorry, I do apologise. Ground 3, yes. Ground 2 has mysteriously disappeared.
Yes.
The passage in Kamara is well known. You probably don't need to go to it. The court's seen it ad nauseum, but the central point of Lord Justice Sales' as he then observation is that it's not appropriate to treat the statutory language as subject to some gloss, and that applies not just to this passage, but actually across section 117C. Very significant obstacles means exactly what it says on the tin. And actually, when one looks at the case of Paveen, and we might just jump over to Paveen for a moment, that's at tab 4 of our skeleton argument, of the authorities bundle, paragraph 9. And again,
yes.
And Lord Justice Underhill, in a sense, partial approval, partial disapproval of Mr. Justice McCloskey's observation in Tree Bowen. But I mean, I think the key is that the very significant obstacles test erects a self-evidently elevated threshold.
Your point is there's no need to put a gloss on it. You
Well,
say,
the-
I'm
the-
applying a test of very significant obstacles. It's a first-tier tribunal judge. He's seen Kamara, knows jolly well what the test is, and identifies the obstacles and then says, I find they're very significant.
I mean, there's not really much more. Much
I mean,
more
that's
to it.
really it, isn't it?
Yes, I mean, the judge did, at the end of the determination, towards the end, recognise that very compelling circumstances was a particularly elevated threshold. In a sense, it's the final question.
Yeah.
What the judge didn't do along the way is saying, well, in the lower lands there are some peaks and some troughs, and there are particularly elevated tests within. I mean, where does it end? In our submission, there was no good reason for the FTT to have to cite authority or to unpack Paveen and Kamara in great detail to explain a legal test which is already perfectly clear, and again to be applied in accordance with common sense. Lord Stevens in SC Jamaica goes on in paragraph 51 to alight upon the next test, which is very significant obstacles to integration, and says,
You say you can't treat Kamara, because Lord Justice Underhill in Parveen said quite rightly that what Lord Justice Sales was addressing in Kamara was the first part of the test, which was the integration, what's meant by integration in this context, and was focusing on that rather than what constituted very serious obstacles. You're not saying, well, simply relying on Kamara is not good enough. You've got to go ahead and mention Parveen or, dare I say, Akomar as well. No, you say this is an FTT judge, knows what the test is, needs to look at what the obstacles are, needs to evaluate what they are, and can do it all in one go.
yes, that's absolutely correct. And if tab 7 of our bundle is the case of AA Nigeria.
Yeah.
That's a judgment of my Lord Justice Moylan. I think Lord Justice Popplewell gives the main judgment. If we that's at tab 7, and really focusing on page 119, paragraph 9. The focus of this paragraph was about the unduly harsh test in the family life exception within 117C, but actually our submission is that what Lord Justice Popplewell says in that paragraph applies with equal force to other parts.
But wasn't what Lord Justice Popplewell was driving at there a practice of saying, look, in X case, somebody had very similar circumstances and that was held not to be unduly harsh, and in Y case, it was held to be duly harsh, and therefore, which side of the line does it go? I think that's what he's actually deprecating there.
Yes, but in the that's absolutely correct. But it also talks about how far does a judge need to go in unpacking and explaining to himself and to any readers that he understands the text.
Cite the leading case, you don't need to cite chunks from it.
Yes.
That's what you're citing this for.
And it's really the last few lines.
Yes.
And actually it's an impediment to the efficient working of judges for determinations to be ever longer and longer as more tests within tests appear in judgments issued by the Court of Appeal, and judges' feet are then held to the fire with reference to those ever increasing.
The real issue is whether or not the FTT judge, with all of the benefits of all of the assumptions that the court has to give, has demonstrated that they've applied the test correctly.
Yes.
You say they have.
Yes, absolutely. That is our submission. And so actually we say that the judge has done precisely what Parveen and Kamara urge of them, which is not to put a gloss on it. The Secretary of State argues that Parveen and Kamara, Parveen in particular, demands that the judge acknowledge the elevated threshold. And we say that that isn't the effect of Parveen, number one. And number two, it is, as a matter of law, is not necessary for a first-tier judge in the discharge of their functions to constantly have to do so. There is, if I can just give paragraph references without needing to go to them, at paragraphs 1-5, this is of the FTT determination. The judge refers several times to the very significant obstacles test. Paras 152, 162, 163 and 174. My submission is that this court can be perfectly satisfied that the judge's citation of Kamara at paragraphs 162 and 173 is done as a self-direction on the meaning of integration and not being deployed in some way as if it were had the effect of lowering the threshold of very significant. There's nothing on the face of the FTT determination to suggest that the FTT believes that the threshold was lowered. And finally, if we can go to ACOM, tab 11. And actually, in my own notes, I flagged up the words "in substance" in paragraph 49. That in a sense, in substance, really does the heavy lifting in a case like this. And that's important because there are numerous potholes in the road for these judges discharging these functions, and it's very easy to, after the event, see if they have tripped up. But actually, the full run of cases going to both very significant obstacles to integration as well as social and cultural integration, the broad thrust of it is that these are broad evaluative assessments, which is a phrase that my lady uses earlier on in ACOM, which I will come to as one of my closing points, is that actually substance is more important than form. That's the bottom line. And for that reason, I submit that there is no error of law as far as the judge's treatment of very significant obstacles to integration to life in Guinea. One point that arose from the Upper Tribunal's treatment of this ground of appeal was that actually there were more factors. If one jumps forward in the FTT determination, when the judge is conducting the final balancing exercise under very significant, under very compelling circumstances, paragraphs 206 to 211 the judge picks up a number of points which could quite easily have been housed earlier on in the significant obstacles to integration. You know, all of these points bleed into each other. There are no clear, bright lines. So, in part, some of the criticism we say that it lies at the heart of the Secretary of State's case is, in fact, a criticism of how the judge organised the determination. The consideration of all the key points going to both grounds of appeal, we say, is present throughout the determination, and that's why there is this. These determinations must be read as a whole. You put one bit of it under the microscope, and you might be able to pull it apart. But when you take a step back and take a panoramic view of it, and that's another example. These are factors at paragraphs 206 to 212, which could have easily been housed in very significant obstacles to integration, and maybe that would have extinguished the ground in respect of very significant obstacles, but a new fire might have been started on very compelling circumstances. They go to both. And actually, when one looks at paragraph 28 of the Upper Tribunal's judgment, that's at page 70 of the core bundle,
Yes. Which paragraph did you say?
paragraph 28.
Thank you.
that point is made in the last few lines. Actually, there's his findings as part of the balancing exercise could have been housed in there and would have strengthened his conclusion.
Yes, I saw
And,
that.
and that we submit is the same in respect of the judge's understanding of the respondent's criminal conduct and his criminal history. It can be found elsewhere. And it may be right that he could have done. We can all mark that. We can all mark that section on social and cultural integration. I'm jumping back now just for a moment. We could have all marked that social and cultural integration and said, well, here are a number of things that he could have done better. But actually, I submit that those two paragraphs, 160 and 161, save him when judged across. When it's judged across the piece, as it were. My final point, really, just some concluding points. It is, if we can go back to AA Nigeria, tab 7.
Yes.
Paragraph 41. And this is really a kind of overarching point. It's the last 6 lines of paragraph 41 as it appears at the bottom of page 127. And the important observations of Lady Hale, in which is quoted the decision of Lord Justice Carnwath as he then was in Murukaka. And as ever, there is always the temptation, the creeping temptation for appellate courts to take the view that this was an unduly or unusually generous view of the facts of the respondent's case. But that, in my submission, doesn't assist the Secretary of State in making good an error of law. And our submission is that the FTT's determination is untainted by legal error. We would respectfully invite the court to dismiss the Secretary of State's appeal. My lady, my lords, there's one very brief final point I wish to make, which is that it remains always open to the Secretary of State to take a fresh view on whether someone's deportation is in the public interest and whether the Article 8 balance needs to be restruck on the most up-to-date facts. That has always remained an option for the Secretary of State. The Secretary of State may well be stuck with findings by the First-tier Tribunal in this case on social and cultural integration. But new facts can be brought to bear. And that assessment will possibly need to be conducted again. I think significant obstacles to integration may well be fixed, as it were, going ahead, given that there's unlikely to be factual flux in the facts as far as that is concerned. And of course, the final balance can be reconducted. But in my submission, this court is concerned with what was before the judge in August of 2023, and is that a determination which is legally flawed or not? And our submission is that it is not. But the Secretary of State has a range of options available to her outside of the judicial system. Unless there's anything else, my lord, my ladies.
No, thank you very much. Yes, Mr. Skinner.
I've just got 4 points to make by way of reply, if I may. The first two just concern the scope of the Secretary of State's case. I think I may have wrongly conceded there was no reasons challenge. In respect of ground 3, if one looks at page 14 where the grounds are, there is expressly a pleaded reasons challenge, as well as a failure to apply the right legal test ground, and that's reflected also in paragraph 41 of my skeleton argument.
Sorry, Mr. Skinner, I missed that.
Well, so did I. So both ways. The second point, just in relation to the scope of my case, my learned friend does a very good job at erecting straw men and then knocking those down. But I just want to be clear that I agree with my learned friend that this court will deprecate attempts to erect tests within tests within tests. That I agree that substance is more important than form. It's not my case that the judge failed in form but applied the right test in substance. My case is that the judge applied the wrong tests in substance. I'm not attempting to introduce a test within a test. I'm just saying that the judge didn't apply the right test. And I'm not. The last thing I'm asking this court to do is to substitute its own view for that of the First-tier Tribunal. I hope from the submissions I've made it's clear that the submissions I'm making are that the First-tier Tribunal erred in law, and I'm not simply making dressing up disagreements with the findings of fact as legal errors. I've identified, I hope, properly arguable and correct, that's obviously for your lordship's and ladyship's judgment, errors of law in the decision of the First-tier Tribunal. Just three other sundry points, if I may. It was suggested that there were periods of non-offending. I've had a look through a very sketch chronology that I put together this morning for myself, and as far as I can see, the only significant period of non-offending was when the Mr. Dabo was in custody and or immigration detention. Otherwise,
Do you have the dates when he was in immigration detention?
I know that he was in immigration detention immediately post his custodial sentence.
That I got. It was the date on which he was released from immigration
I
detention.
don't. I
I'm
can
not
take
sure
instructions and see if we can find out. I'm not sure whether I can find out immediately, but I
No,
can certainly
Well,
provide.
perhaps you can let us know.
Of course. I'll find that out and obviously share that with my own friend and then let the court know. But the short point there is that that's just not borne out by the PNC. That basically there's offending every year other than that period, perhaps shortly after as well, of his release. Just in relation to the passage that my Lord Justice Moylan adverted to in SC about the approach that the tribunal had taken in
Yes.
SC. I mean, the point that I would make, it was paragraph 82 of SC.
Yes.
The important point there, from my perspective, is that the judge there did consider whether the offending indicated a lack of social integration, and that's just the bit that's missing here, we say. And then finally, my learned friend invited the court to consider the Upper Tribunal's decision. I'm not going to go back over my submissions in relation to that. I would just draw attention, if I may, to I've dealt with the Upper Tribunal's decision at its paragraphs 29 to 31 and 42 to 43 of my skeleton, and I would just stand on what I've said there.
Thank you.
Unless I can assist.
Anything else? No, thank you very much. Thank you both for your respective submissions. And we will be reserving our judgments. They will be provided to you in draft for the usual limited purposes, and we would anticipate that once you've got them, you will be able to agree a draft order, because we'll be indicating what that would be in our judgments. So, thank you very much.
Guys, if able,